have said, this statutory inquiry into events at Brook House in 2017 was announced in November 2019. The inquiry's progress has, at times, been slower than intended, partly as a result of the COVID-19 global pandemic. I'm aware that many of the core participants in this inquiry, and particularly those who were formally detained, have very much wanted to have the opportunity to have their accounts heard. And that is why today is such a key day for the inquiry. Before we hear from Council, a couple of points on housekeeping, if I may. We will generally sit each day from 10 a.m. till 4 p.m. with a lunch break from around 1 o'clock to 2 o'clock and a 15-minute break in the morning and afternoon. The exception to this will be Fridays, when we will sit from 9:30 a.m. to 1:30 p.m. with a longer morning break of 30 minutes. The hearing transcript is recorded simultaneously on screens throughout the room and will be published at the end of each day on the inquiry website. Any directions arising from the day's hearing will also be published on the website. As you will hear in more detail from Council, there are anonymity arrangements in place for witnesses. Ciphering and redactions have also been used in relation to the evidence in accordance with the inquiry's redaction protocol and restriction order, both of which are available on the website. If there is an inadvertent breach of a restriction order, I will ask that the simultaneous recording be stopped momentarily so that the issue can be addressed as appropriate. I would now like to invite Counsel to the inquiry, Mr. Brian Altman QC, to address me. Please do go ahead, Mr. Altman.
Thank you, Chair. Well, on Monday, the 4th of September of 2017, as you've said, BBC's Panorama broadcast a programme bearing the title Undercover: Britain's Immigration Secrets. The programme sought to expose the mistreatment of formerly detained persons at Brook House, which was and is an immigration removal centre, or an IRC, then operated by G4S. Material covertly recorded by Callum Tully, an undercover reporter for the BBC, over a 3-month period, from the 19th of April 2017 to the 17th of July 2017, showed treatment of detained persons of a dehumanising and depersonalising nature, including physical assaults and verbal and racist abuse. Staff, including healthcare staff, were involved in the misconduct. The covertly recorded footage was later described by the Immigration Minister as, quote, appalling, end quote. Neither Home Office staff located at Brook House nor the Independent Monitoring Board, the IMB, with oversight at Brook House, raised concerns about the type of treatment of those detained at Brook House aired on Panorama. Her Majesty's Inspector of Prisons, HMIP, who had oversight of the centre and who had inspected Brook House in late 2016, raised no significant concerns regarding mistreatment in their report published on the 10th of March 2017. On the contrary, it concluded that Brook House was, quote, reasonably good, end quote, and making, quote, excellent progress, end quote. In June 2017, 2 formerly detained persons at Brook House, ciphered by this inquiry as D1527 and D687, both core participants in the inquiry, challenged the failure of the Secretary of State for the Home Department to order an investigation in the High Court. Initially, the Home Secretary lodged an acknowledgement of service indicating an intention to contest the claim on grounds that the Home Department's investigatory duty under Article 3 of the European Convention on Human Rights had in effect been discharged by a number of other separate inquiries conducted by different bodies following the broadcasting of the Panorama programme. However, during the preliminary stage of the men's judicial challenge, counsel for the Home Secretary said, quote, "The immigration minister has said that she was appalled by the panorama footage and is determined that lessons are learned and there is a change of culture," end quote. In September 2018, the Home Department asked the Prisons and Probation Ombudsman, PPO, to conduct a special investigation into the matters raised by the programme. In light of that decision, the High Court was asked to determine whether a special investigation conducted by the PPO was an inquiry that was compliant with Article 3 of the European Convention, where it had no power to compel witnesses, no obligation to hold at least some hearings in public, and could not allow properly funded representation for D1527 and D687 during the investigation. The judgment of the High Court, given on the 14th of June 2019, led the Home Department on the 5th of November 2019 to convert the PPO's special investigation, which you had been appointed to lead in March 2019, into a statutory public inquiry under Section 15 of the Inquiries Act of 2005, and appointed you the chair of this inquiry, as you have said, the Brook House inquiry. And so it is today you begin the hearings in the Brook House inquiry, which you've determined should be held in 2 phases. As you've said, today begins phase 1 with this opening statement, which will be followed by the opening statements from core participants. Next week, you will start hearing the evidence, which will continue into a 3rd and final week of this phase, phase 1. Closing statements, however, will take place at the conclusion of phase 2 of these hearings, which will begin, again as you have said, in February next year and is expected to last some 4 to 5 weeks. I'll return in a moment to explain the 2 phases to these inquiry hearings. But may I first make introductions of those who are represented before you today. As you know, I am Brian Altman, Queen's Counsel, lead counsel to the inquiry. I'm assisted by Ms. Sarah Simcock, Ms. Saoirse Townsend, Mr. Paul Livingston, Ms. Jo Moore, and Ms. Harriet Wakeman and Mr. Paul Edunast, who the latter two will be here from time to time. There are 24 core participants in all, who I shall introduce shortly. They comprise 12 formerly detained persons, 3 former employees of G4S, Owen Syred, Reverend Nathan Ward, and Nathan Ring. There are 2 non-governmental organisations, NGOs, Medical Justice and the Gatwick Detainees Welfare Group, GDWG. And the remaining 7 core participants are the BBC, the Home Office, Her Majesty's Chief Inspector of Prisons, the Independent Monitoring Board, G4S Care and Justice Services UK Limited, and G4S Health Services UK Limited, as well as Practice Plus Group. So with that, let me now please introduce their representatives, and I am doing this by groups. D1851, D1527, D2077, D1914, D1538, and Reverend Nathan Ward are represented by Stephanie Harrison, Queen's Counsel, Alex Goodman, Una Morris, and Zainal Jafferji, as I understand it, for D1851 only, all instructed by Duncan Lewis. D1473, D801, D2158, D1713, D1275, and Medical Justice, also represented by Ms. Stephanie Harrison, Queen's Counsel, but with her, for that group, Shu-Shin Liu and Laura Profumo, all represented by Bat Murphy. I should say all instructed by Bat Murphy. D687, D390, and the Gatwick Detainees Welfare Group, represented by Mr. Nick Armstrong, Jesse Nichols, and Una Morris, instructed by Dayton Pierce Glynn. Owen Syred is represented by Brian Stanton and Deirdre Domingo, solicitors of Innovo Law. The Home Office by Julian Blake, Emily Wilsden, Rebecca Handcock, instructed by the Government Legal Department. The BBC is represented by Jude Bunting, and with him Stephanie Davis, instructed in-house by the BBC. Her Majesty's Inspector of Prisons is represented by Amy Mannion and Jonathan Metzer, instructed by the Government Legal Department. G4S Care and Justice and G4S Health Services, represented by Mr. Andrew Sharland, Queen's Counsel, and with him Daniel Eisenberg, instructed by G4S in-house and I think together with DWF solicitors. The Independent Monitoring Board is represented by Jonathan Dixie and Jennifer Wright, instructed by the Government Legal Department. Nathan Ring, we understand, is represented by Ben Harrison of Milner's Solicitors. And finally, Practice Plus Group is represented by Cecily White, instructed by Hill Dickinson. So that is the representation. Let me come on to the two phases of these inquiry hearings. Now, as I have said, the inquiry is conducting these hearings in two parts or phases. In the first phase, beginning today, you will be hearing from witnesses, from a Home Office witness to set the scene for Brook House, against which the evidence that follows may be better understood. That will include evidence about the contractual arrangements between G4S and the Home Office, Brook House's infrastructure and generally how it operated, just to set the scene against which everything else can be understood. The scene having been set, we'll be hearing from Callum Tully, the BBC undercover journalist who worked at Brook House as an assistant detention custody officer to begin with, an ACO, and then as a detention custody officer, a DCO, during the relevant period, and that's a term that we will come back to again and again, and the relevant period for the purposes of this inquiry is from the 1st of April 2017 to the end of August, the 31st of August of that year. Callum Tully will tell us about his work there, what he experienced while employed at Brook House, how and why he took his concerns to the BBC, and how he went about filming inside the institution that led to the Panorama programme. We will also be showing him a selection of the key footage in the course of the evidence, and we will be seeking his assistance with the context of those incidents he filmed. Thereafter, we will hear live evidence from three formerly detained persons and their particular experiences of their treatment in Brook House. They are ciphered as D1618, D668, and D1851. We also intend to read or summarize the accounts of a number of other formerly detained men. Others' accounts will be heard in phase 2, Towards the end of the Phase 1 hearings, the inquiry shall also be receiving evidence from Reverend Ward and Owen Syred, as I've already said, former members of staff at Brook House, from Dr. Dominic Aitken, an academic who spent time inside Brook House in the summer of 2017 doing research, and from Anna Pincus, James Wilson, and Jamie McPherson of the Gatwick Detainees Welfare Group, as well as Anton Bowl of Forward Trust and Sheila Reynolds from Freedom from Torture. This is the opening statement for Phase 1 of the hearings, and so it deals with the evidence the inquiry will hear in Phase 1. Phase 2 will begin with a further opening statement, which we will deal with the evidence the inquiry is to hear in that part of the hearings. In Phase 2, Callum Tully will be recalled to give further live evidence about matters not already covered in his evidence in the Phase 1 hearing. It will also include seeking his response to any criticism of him by former staff members of G4S featured in the Panorama programme and indeed others. In Phase 2, you will also hear live evidence from staff members or former staff members of G4S. They will include senior management witnesses and those who worked on the ground in Brook House during the relevant period, some of whom appeared in the BBC footage broadcast in the Panorama programme, including those accused of the mistreatment of formerly detained persons, as well as others. Similarly, you will hear live evidence from the management and members of the healthcare staff at Brook House, including GPs and nurses, in relation to the provision of healthcare in Brook House, the management of vulnerable detained persons, those presenting a risk of self-harm or suicide, and those with substance misuse issues. There'll be evidence on how the process under Rule 35 of the Detention Centre Rules of 2001 operated. That is to say, the provision of a report by a medical practitioner to the centre manager, where it's likely that the detained person's health would be injuriously affected by continued detention, or where the medical practitioner suspects that a detained person has suicidal ideation, or where there is a concern that a detained person may have been a victim of torture, and the challenges for medical practitioners in those circumstances. You'll also hear in Phase 2 from a witness from Medical Justice, a charity which provided medico-legal reports and advice to detained persons. There'll be evidence from senior Home Office officials who will give evidence concerning their roles and their responsibilities in relation to Brook House and issues such as contractual arrangements with G4S, staffing levels, the system for investigation of complaints, and any action taken as a result of the Panorama programme. Witnesses from organisations responsible for the oversight and monitoring of Brook House, such as the IMB, Her Majesty's Inspectorate of Prisons, the National Preventative Mechanism, the NPM, and the Home Office Professional Standards Unit, the PSU, will also be here to give live evidence. The Phase 2 hearings will also comprise corporate evidence, both from G4S Health Services and G4S Care and Justice, as well as from Serco, who now run Brook House, and Practice Plus Group, a core participant who now run healthcare services at Brook House, about current practice there, in order to inform any recommendations you wish to consider making in your report. Finally, there will also be live evidence from the experts that you have commissioned, Dr. Hard on healthcare issues at Brook House, Professor Bosworth on the cultural issues at Brook House, and from Jonathan Collier on issues regarding the use of force at Brook House. In the course of these hearings, we're going to be using as a guide what we call a schedule of incidents, which has been created by counsel to the inquiry and disclosed to court participants. It incorporates a total of around 50 key or significant incidents, which we will be focusing on in the course of these hearings. Albeit, Chair, it's of course open to you to take account of the whole of the evidence received by you in these hearings in order to consider the big picture of the experiences of detained persons at Brook House when formulating your report in due course. The schedule is designed to be a living document, so it can be updated and revised as necessary as we go along. And in substance, it includes the 8 incidents identified in the BBC footage, the key incidents, other significant use of force incidents not covered in the BBC footage, alleged assaults of detained persons by staff, significant suicide attempts or self-harm not covered in the BBC footage, significant incidents relating to substance misuse not covered in the footage, verbal abuse such as racist comments between staff members, incidents leading to disciplinary action against staff members, and incidents which led to complaints and consequent investigations by the PSU. The inquiry will also be investigating the adequacy or appropriateness of healthcare provision with the assistance of Dr. Hard. Let me deal now, please, with the inquiry's terms of reference and its scope. The inquiry's terms of reference, as you have said, Chair, the full terms of which may be found on the inquiry's website, are to, quote, reach conclusions with regard to the treatment of detainees where there is credible evidence of mistreatment, end quote, at Brook House during what I have already described as the relevant period, 1st of April to the 31st of August of 2017. To identify who was responsible for that mistreatment, what caused or contributed to that mistreatment, and crucially, what changes might be needed to prevent a repeat of them. And the term mistreatment refers to treatment that is contrary to Article 3 of the European Convention, that is to say, torture or inhuman or degrading treatment or punishment. In your opening statement of the 21st of April of last year, 2020, you made a number of important observations about detention that bear repetition now. You said that it is hard for many people to understand how it feels to be held in detention. And let me quote you. You said, "It is hard to imagine the experience of being separated from our family, our homes, and communities. The effects can be profoundly humiliating and traumatic. If you have significant uncertainty about what is going to happen to you and your family, your vulnerability may be even greater. Language barriers can cause difficulties communicating with other detainees and staff, and you may be experiencing significant mental health issues. You may not understand the legal processes that you are subject to, and you may greatly fear the outcome of those proceedings," and that ends the quotation. As you put it, from your own experience of working with adults and children detained in a variety of situations and locations around the world, quote, "Inherent vulnerability goes hand in hand with the experience of detention," end quote. You added, quote, "The public expects the Home Office to provide a safe, decent, and humane environment for anyone who it or its contractors hold in immigration detention." The treatment revealed in the Panorama documentary was shocking and has no place in a decent and humane immigration detention system. It is this inquiry's role to examine what took place at Brook House and how treatment of the nature experienced was able to happen. Specifically, the inquiry will examine whether the treatment experienced in Brook House was contrary to Article 3 of the European Convention on Human Rights and therefore amounted to inhuman or degrading treatment or punishment, and that ends that quotation. In your opening statement and repeated in your determination on the scope of the inquiry dated the 6th of January of this year, you identified 5 central questions that require addressing by the inquiry first. The extent and severity of the mistreatment at Brook House during the material time and to examine who perpetrated it. Second, the extent to which policies, practices, staffing and management arrangements at Brook House caused or contributed to any identified mistreatment. And this question requires an examination, you said, of a series of issues which you set out in your determination on scope. And there are several of them. Direct management and leadership at Brook House, staff and management training, induction and support, staffing levels, prevalence of racist attitudes, behaviours, and measures for addressing such attitudes or behaviours, staff and management culture, the co-location of time-served foreign national offenders, or TSFNOs, and asylum seekers, the assessment of vulnerability, including the process referred to as Rule 35 and the adults at risk policy, the extent and suitability of the specialist mental health provision, the use of control and restraint techniques, including pain compliance, the availability of other methods for encouraging good order and discipline and dealing with non-compliance, the control of drug availability and use, response to bullying or intimidation of detainees, the use of segregation, management of self-harm and food refusal, language barriers and the use of interpreters, and management of healthcare staff. The third of the 5 central questions is the adequacy of the safeguards designed to detect mistreatment. And you said this means examining a series of issues, which are the procedures for formerly detained persons to make complaints and the responses to any such complaints, the recording and monitoring of the use of force, Home Office monitoring and oversight of Brook House, including the role of the Professional Standards Unit, the PSU, the adequacy of the contractual framework for identifying and responding to mistreatment, the IMB's monitoring of Brook House, HMIP's inspection of Brook House, informal mechanisms for raising concerns, including the role of the chaplaincy, and whistleblowing procedures and protections for staff. The fourth central question, what changes have been made in response to the Panorama documentary? And fifth, whether those changes are adequate or need to be improved upon. The terms of reference for this inquiry are such that the inquiry's focus is on the treatment of those detained in Brook House during the relevant period. What the inquiry is not tasked with or able to investigate is this country's system of immigration detention more widely. Now, let me say a few things, please, about previous investigations and reviews. Several investigations arising from the events exposed by the BBC's Panorama programme have already taken place and reported. And I'm going to return to the details of two of them towards the end of this opening statement. But let me just set them out in summary. On the 21st of November of 2017, 2 months after the programme was screened, Stephen Shaw was asked by the Home Office to extend the scope of his follow-up review on the welfare in detention of vulnerable persons, which had been previously commissioned. Second, also that same month, G4S commissioned Verita to carry out an investigation by Kate Lampard and Ed Marsden into the issues raised by the programme. The report was published in redacted form in November 2018 and is referred to as the Lampard Report. Third, the Home Office PSU began an internal investigation which reported in February 2018. Fourth, the Home Affairs Select Committee, HASC, H-A-S-C, published a report on the 21st of March of 2019, having inquired into immigration detention with particular focus on the management of vulnerable individuals. And fifth and finally, there was the National Audit Office, the NAO report, published in July 2019, which reported on the design of the contract between the Home Office and G4S, its operation and Home Office oversight. As you said in your determination on the scope of the inquiry of the 6th of January of this year, the inquiry needs to build on the findings of other relevant reviews and investigations and will not seek to duplicate the work of others unless evidence received by the inquiry requires you to revisit the work or conclusions of other investigations. So let me please come to what is really at the heart of this inquiry and that which underlies its establishment, and that's the BBC footage, some of which aired in the Panorama programme in September 2017. Of the 109 hours of footage recorded inside Brook House by the BBC's undercover reporter, Callum Tully, the inquiry has received and reviewed over 90 hours of recordings, of which about 4 hours has been identified as what we call key relevant footage. Disclosure has been made to core participants of the 4 hours or so of video footage. Other footage has been disclosed following specific requests made to the inquiry by core participants. The remainder of the relevant footage has been disclosed only by the disclosure of transcripts, where the inquiry was satisfied that the content of the footage was relevant, but that seeing the footage itself didn't add anything to the evidence. For example, where there was a conversation between staff members. Callum Tully also made video diaries at the end of a shift, and he did so on 36 occasions, summarising the shift he had been on and any notable events. Transcripts of those video diaries have been made, and they have also been disclosed to core participants, except in one instance, where the video diary itself has been disclosed in addition to the transcript. CCTV and body-worn camera footage of incidents inside Brook House has also been disclosed. Sections of the key footage will be shown in the course of the hearings. However, except where a formally detained person has specifically requested otherwise, their faces will be blurred or pixelated out in the footage. Even then, where a formerly detained person has requested that his face be shown in open hearings, his identity will nonetheless remain anonymized in subtitling by the use of ciphering, consistent with the inquiry's protocol for the redaction of documents, your determination, Chair, on the inquiry's approach to the use, publication and reporting of BBC footage dated the 13th of October of this year, and the restriction order made by you yesterday, the 22nd of November. And his name will remain edited from the audio track. In all other cases, the faces of formerly detained persons will be blurred or pixelated out in the footage, and their identity anonymized in the ways I've indicated. Where, however, during the course of the hearing, it's necessary to put to a witness the wholly unedited version of a piece of footage, for instance, in order to demonstrate visually the effect of an incident of mistreatment on a detained person, that will be achieved by inviting you to go into closed session, where the footage can be shown. If necessary, questions may be asked, and on our return into open session, a summary of what took place can be provided, and the examination of the witness can then continue. In relation to staff members and former staff members of G4S, the Home Office, and others, such as individuals working for inspectorates, NGOs, and the BBC, the approach of the inquiry has been not to redact their names in disclosed documents unless the inquiry considers that their involvement was wholly irrelevant. The inquiry's starting point has been, and remains, that the identities of those individuals are relevant. Not least, it is the conduct of many of them, as well as the organisations for which they worked, which is the subject matter and focus of this inquiry and requires the greatest public scrutiny. Let me say something about witness evidence. The inquiry has received witness statements from formerly detained persons. Some are giving evidence in this phase, phase 1, while others will be asked to do so in phase 2. Inevitably, some formerly detained persons have been untraceable. Some of those who have been traced are vulnerable and are simply unable or unwilling to give live evidence or to provide evidence in any other way. In the case of formerly detained persons who have given statements to the inquiry but are unable to give live evidence, the inquiry will adduce their accounts by reading or summarizing their statements and any previous accounts given to other tribunals or investigations. In the cases of those who have provided no inquiry statement, the inquiry will adduce any previous accounts given to other tribunals or investigations, as well as the relevant content of medical reports provided for other purposes, and that's in order to provide a breadth of experience of those who were detained in Brook House during the relevant period. There has been reasonable engagement by staff and former staff members of Brook House. The inquiry is continuing to send out Rule 9 requests, that is to say, requests for witness statements, with a view to the evidence in phase 2 of the inquiry. And while some have responded to formal requests for statements or have returned pro forma questionnaires, many have not. This despite the Attorney General issuing an undertaking in January of this year that in the case of any person who provides oral or written evidence to the inquiry, that evidence will not be used in evidence against that person in any criminal investigation or proceedings unless it relates to that person's prosecution for giving false evidence or for an offence under Section 35 of the 2005 Inquiries Act. Others have informed the inquiry about vulnerabilities which they say render them medically incapable of assisting. The result of the non-engagement by some staff or former staff members of Brook House has been for you to invoke your compulsory powers under Section 21 of the 2005 Act in order to compel the provision of evidence to the inquiry. After all, one of the features which led the High Court in 2019 to determine that the PPO's special investigation was not Article 3 compliant was the absence of any power to compel witnesses. It may be, Chair, that you will consider it necessary to issue further Section 21 notices in due course. And for the sake of completeness, in addition to the undertaking given by the Attorney General, of which I have just made mention, in July of this year, the Immigration Minister issued an undertaking at your request that where any current or former immigration detained person provides evidence to the inquiry, the Secretary of State may not use the evidence against him in the course of any immigration proceedings, in any immigration decision made by the Secretary of State, in any decision to detain or to seek to impose conditions in respect of immigration bail, or for the purpose of investigating any immigration matter or deciding whether to bring immigration proceedings, in particular, unless the former detained person has chosen to rely on the evidence and it is necessary for the Secretary of State to correct a false impression or assertion made by the evidence given. Let me now come on, please, to say something about the processes and procedures that will be adopted. To assist everyone's understanding, the evidence will be presented essentially in one of two ways. Witnesses will either be called live and their evidence live streamed online, albeit with a 3-minute delay, or if not called live, as I have already indicated, witnesses' evidence will at appropriate points be read or summarized by counsel and formally adduced into evidence by such means. Documents or parts of them that are referred to will be published on the inquiry's website, and video footage that is shown during open hearings will be made available. Because you, Chair, determined on the 13th of October that footage shown in open session would not depict the faces of formerly detained persons, as I've already said, yesterday you made a restriction order to restrict the publication of the identity of those formerly detained persons who had not requested it. In the event of an accidental or deliberate revelation of identity in the course of open hearing sessions, we will ask for the live stream to be stopped so that the broadcast can be edited to remove the evidence which would breach the restriction order. The transcript of the proceedings will also be redacted to remove the identity of that person if necessary. Most of the evidence in these hearings will be heard in open session. That's to say, hearings in which the public can see and hear the evidence in person or online. Where, for the reasons I've already given, evidence has to be heard in closed session because, as I have explained, we have to show a witness unedited footage. The public will not be admitted into the hearing room and the evidence will not be live streamed. But everyone else, core participants, their legal teams, and accredited members of the press who are present will be able to see and hear their evidence in the hearing room, but there will be no live stream of that part of the evidence. And can I add, finally, at this juncture, that the terminology used in this environment has evolved and is changing, and we shall all do our best to use the right terminology throughout. but the documentation to which we shall be referring from time to time has not always caught up and uses language no longer thought appropriate. And while I'm on the subject of language, occasionally in the course of this opening statement, I am going to resort to using only the last names of persons. If and when I do so, it is not done out of any discourtesy, but only for reasons of economy, and I can assure those concerned that no offence is intended. Well, Chair, that ends, as you know, the first section of my four-part opening statement, which gives everybody else an indication of what's to come. I'm not going to promise they're all of the same length, though. But we're slightly early, but perhaps that would be a good moment for you to rise for our mid-morning break.
I agree. Thank you very much.
What's that? So far. It's always the afternoons that get me.
Thank you.
Thank you, Chair. Let me deal then with general matters of background. Brook House is a purpose-built immigration removal centre located on the southern perimeter of London's Gatwick Airport. It opened in March 2009, and while always intended to be an immigration removal centre, it was built to the security specifications of a Category B prison. Nearby, and also on the airport site, is an older and smaller facility, Tinsley House. Together, they are known as the Gatwick Immigration Removal Centres. Brook House is now managed and run by Serco, and as I've said, Practice Plus Group now runs its healthcare services. It was initially managed from opening by G4S under a contract which was between the Home Office and a company known as GSL Limited. GSL Limited was bought by G4S before Brook House opened, and G4S assumed its contractual obligations. The contract was then extended in 2018. In September 2019, G4S announced that it would no longer be operating at the Gatwick centres, and in February 2020, Serco was awarded the contract to manage both Brook House and Tinsley House. Serco took over the management of Brook House in May 2020 under a contract which runs until at least 2028. The initial contract term under which G4S ran Brook House was 8 years. In 2016, an extension of 15 months was granted from February 2017 to May 2018. The contract was then due to expire in May 2018 and was put out to tender in January 2017. From then until March of that year, 2017, G4S senior managers worked on a rebid for the new contract. The Home Office announced in May 2018 that G4S's contract would be extended for a further 2 years, despite Panorama having been broadcast some 8 months earlier. The Home Office contract required G4S to manage, staff and maintain Brook House. In return for this service, the Home Office paid G4S fixed monthly fees, which were subject to performance-related deductions. The monthly fee paid by the Home Office rose with inflation from 2009 when it was set, and during the relevant period was around £1 million a month. G4S subcontracted some of its services to other companies. During the relevant period, Aramark contracted with G4S to provide catering, a shop for the detained men, and cleaning services. Healthcare at Brook House was provided by G4S Health Services pursuant to a separate contract with NHS England. G4S also provided training to Brook House staff. The content of the training was approved by the Home Office. However, no penalties attached to any failure to provide that training, nor was the quality of the training stipulated in the contract, although the nature of the mandatory training was. The contract between the Home Office and G4S consisted of several schedules. Schedule D, in particular, titled Operational Specifications, set out the various requirements which G4S was required to meet under headings including maintenance of security and safety, healthcare, catering, and welfare and regime. Schedule G which was titled Performance Evaluation, set out a service points value to be awarded for service failings to meet any of these operational requirements. Each month, these would be converted into a financial penalty, which would be subtracted from the monthly payment to G4S. And the amount of the penalty would depend on the nature of the failure. Some failings were just so significant that they carried a flat service credit penalty. So, escape from Brook House would lead to a service credit penalty of £30,000 per incident, whereas self-harm resulting in death, defined as self-harm of a detained person resulting in their death, involving any failure by G4S to follow procedures for the safety of detained persons, attracted a penalty of £10,000 per incident. However, self-harm resulting in injury, as opposed to death, resulting in injury, defined as self-harm by a detained person requiring any form of healthcare and involving any failure by G4S to follow procedures for the safety of detained persons, attracted a penalty of £716 per incident, together with 400 service points. Significant performance failings, including escape and self-harm resulting in death, resulted in fixed financial penalties and was not capable of being mitigated. Other failures to meet agreed performance standards, of which self-harm resulting in injury, where there was a G4S failure, was one, among many others, gave rise to a penalty point deduction. The deduction depended on the seriousness of the failing. If there was mitigation for the failing, which was accepted by the Home Office, no penalty was imposed. By 2017, performance was primarily assessed on delivery against 25 key performance indicators. According to Ben Saunders, Brook House's then director, during the relevant period, G4S's focus was very much on contractual delivery. He felt the focus was on targets and profit. He noted that the contracts had a set profit margin, but there was an expectation that he would deliver more. Money saved, he said, was not for reinvestment in Brook House. Quote, staffing vacancies generated some profits because you were saving on costs that you had already looked at, end quote, is what he had to say. Now, let me deal with the physical environment of Brook House, and I'm now going to ask the evidence handler, please, to put up on screen, first of all, a plan, CJS 004587. And this is a plan of the ground floor. We have the ground floor up on screen. And if we can flick up or down, as the case may be, to the next page, probably down, page 2, the first floor, and again, please, to the next, the second floor. Can we go back to the ground on page 1? This is a representative plan. It's not a plan drawer's plan. It's not drawn to scale, and I'm afraid it's the best that we have. And as has been pointed out, and it's perfectly clear, although we can see in the 4 corners of the plan as we look down on it, we have 4 wings, which I'll come to describe in a minute, shaded in blue. We also have shaded in green courtyards, and of course if we go to the next page, page 2, the way that the plan has been drawn rather looks as if the floors above cover over the courtyard, and that clearly isn't the case. But as I say, it's the best that we have been able to muster, despite the inquiry's best efforts to get something calling itself a decent plan from anyone. I'm not going to go through all of the labelling on the plans. Everybody has, I hope, seen it and been able to study it and identify, insofar as they're able, where the various areas on each of the floors were, offices and the like, and so on. But what I will perhaps put up and ask to keep up for the moment, and I don't know if it can be done side by side, but certainly one of the following. Can we put up for the moment some images, INQ 000062, please? Take down the plan and put up the image. Are we able to, I don't know if we're able to put up images side by side or just one at a time on the screen. If we can, the next one is INQ 000063. And I suspect this is going to be more helpful than what we were just looking at. I'll just wait for a moment to see if the technicians can put them up side by side. If that's not possible, I'll just carry on. Brook House was built with an operational capacity of 448 people. Let's leave this one up on screen, please. Detained under immigration powers. And when constructed, it was the largest facility of its kind in the UK. Its capacity was expanded in May 2017 in order to house 508 people. And the centre comprises 3 buildings. The first is a non-residential 2-storey building. And we're actually looking, if you like, at the backside of the immigration centre. We can see the runway perimeter road, which is at the top of this plan, going left to right. And so the first building, the one I'm describing, the first non-residential 2-storey building, is the one at the top of this image. And that contains the gatehouse, which is the entrance and exit point for members of staff, escort vans and other official vehicles, and something called the SAT desk, SAT, SAT desk, where people visiting their detained friends or relatives enter, are searched and escorted to the visit hall, which is in the main building. The first building also contains training rooms and the control room. And from the control room, all parts of the centre are monitored by CCTV. And detention custody officers, and we'll get used to the acronym DCOs, working in the control room, also operate almost all electronic doors within the centre, and they make radio announcements for staff on site. Next to this is a small second building, which is a visit centre where visitors are checked in before being taken to the SAT desk. The third and main building has 3 stories, and so that's the building we're looking at in the centre of the image, and it contains the residential part of the centre. And from above, it looks like a capital H shape. When entering the residential block of Brook House, you first come across a reception centre where detained persons are admitted to and discharged from it. For residential use, Brook House is divided into 5 wings, and they have various titles: Arran, Beck, Clyde, Dove, and Eden. Sometimes Alpha, Bravo, Charlie, Delta, and Echo, or just plain old A, B, C, D, and E wings. For ease of reference, at least for now, I'm going to refer to them as A, B, and C, etc. wings. A wing, C wing, and D wing cover over 3 floors or 3 stories. On each floor, there are around 20 double occupancy rooms, sometimes referred to by staff members and indeed others as cells. And they house the detained men. The rooms have 2 single beds. When capacity was increased in May 2017, 60 of these single beds were replaced with bunk beds so that those rooms could hold 3 people. On the ground floor of each of the wings, there is a wing office where staff members are based, an open area for detained persons with seating, pool, and tennis tables, and a food counter where all meals are served. On the first and second floor are corridors from which the rooms can be accessed. And there is open space between the floors covered by wire netting. The wings also have communal showers and laundry rooms. B wing is similar to A, C, and D, but B wing only covers 2 stories as against 3. During the relevant period, let me remind you, the 1st of April to the 31st of August 2017, B wing was the induction wing, where detained individuals were supposed to spend the first few nights of their detention before being moved to one of the other wings. E wing was on the ground floor only and contained space for up to 13 detained persons. Each room had 2 beds, but they were habitually used for single occupancy only. 2 of the rooms were designed for constant supervision, so instead of a small viewing panel, they had large transparent panes looking into the room from the corridor. They were used for men considered to be at risk of self-harm or suicide, or those who were on hunger strike. A member of staff would continuously observe the individual from outside the room. The rest of E-Wing housed individuals who had been placed there for reasons including their mental health, vulnerability, their violent or difficult behaviour, or because they were recently discharged from what was known as the Care and Separation Unit, the CSU. E-Wing was also used for any detained person suspected to be under 18 years of age. And indeed, next to E-Wing, which was the CSU, that unit had 6 rooms containing a single bed and no other furniture or amenities. And detained persons would be housed in these rooms if they were separated from association or placed under temporary confinement under what were known as Rules 40 and 42 of the Detention Centre Rules 2001. They'd be allowed to leave the room for an hour per day, and I'm going to return to the issue of Rule 40 and 42 later. Next to each wing, at ground floor level, in the inside of the capital H shape, and I wonder if the image can go back up on screen, please, was a secure courtyard, and the courtyard was used by detained men for sport or fresh air. INQ 000062 or 63, please. I don't know if, Chair, if there is a gremlin in the with RTS. I can carry on though for the moment.
Thank you.
The healthcare department was situated on the first floor and contained an office, a GP room, a nurse's clinic, and a pharmacy. There was also a room nearby for mental health care, and on the ground floor, there were 2 healthcare admissions rooms for initial assessment. Healthcare was available 24 hours a day, 7 days a week. The nurse triage clinic was a walk-in service that was open between 9:30 and 11:30 in the morning and between 2:30 and 3:30 in the afternoon. The pharmacy opened 3 times a day for 45 minutes a time, and the GP service was appointment-based. The main building also contained communal areas and rooms for the detained population, including a gym, a chapel, a mosque, a multi-faith room, a library and activity office, a classroom, IT rooms, and a craft room. Different parts of the centre were joined by corridors, but the detained men didn't have free access within the centre to the various parts or to each other's wings. Also in the main building were rooms which were not accessible to the detained men, including staff canteen, human resources and senior management team offices, which were on the 2nd floor, a security and administration office, and a kitchen, although some detained people were employed to work in the kitchen during the relevant time. The visit hall was on the 1st floor, and this is where both social and legal visits would be held, and within this hall was the welfare office. The Forward Trust Office, where detained persons could access support around drug use, that was on the 1st floor. I'm going now to deal with the types of issues which are exposed by the evidence that the inquiry has seen. I'm going to begin with staffing and the resident population at Brook House. The evidence received by the inquiry has exposed a number of issues at Brook House during the relevant time. For the first, the issue of so-called time-served foreign national offenders, TSFNOs, those who have completed sentences of imprisonment and were in detention awaiting deportation. On average, around 35% of those detained at Brook House were TSFNOs. G4S and IMB figures suggest the average was 33%. Housing TSFNOs with those who had no criminal record and had never experienced custody, along with men who were often vulnerable due to a past history of torture or mental health problems, could be problematic. Chair, you may wish to consider whether the prison-like environment and an atmosphere of intimidation meant that some detained persons didn't feel safe, were vulnerable to aggression from other detained persons, and likely to experience a deterioration in their mental health. Difficulties were particularly created on E-Wing, when those detained persons who were most vulnerable due to a risk of self-harm or suicide, their mental health condition, or because they may have been under 18, were housed together with detained persons exhibiting challenging, disruptive, or violent behaviour. Detained persons could be sent to E-Wing for a wide variety of reasons which were not necessarily compatible with the care and welfare of each individual group, particularly in an environment where some staff members appear to have regarded those who were vulnerable as putting it on, or being deliberately obstructive or manipulative, as opposed to manifesting behaviour due to distress or a deterioration in their mental health. You may wish to consider whether there was a general problem in Brook House during the relevant period with senior management being or appearing to be inaccessible to the junior management, in other words, not only the detention custody officers, the DCOs, but also the detention custody managers, DCMs. with very little leadership or interaction taking place. It's for you to consider whether this led to cliques forming in which bad behaviour was not merely tolerated but admired. From the BBC footage alone, there is evidence of bravado, mockery, macho behaviour and banter, which may have normalised disdain for, degradation of, and even violence towards detained persons. You may conclude that Brook House was often severely understaffed. Short staffing appears to have been an almost daily occurrence, with the residential wings not having sufficient staff working on them. Members of staff were often not relieved in order to go on a break. The three main residential wings each housed up to 140 detained persons. Only 2 DCOs working on each wing was considered by many to be inadequate to care for detained persons, particularly when part of their duties took one DCO off the wing in order to carry out tasks, leaving only one DCO on the wing. High levels of the management of detained persons on ACDT. It's another acronym we will learn about, the Assessment, Care, Detention and Teamwork Scheme for managing detained persons at risk of self-harm or suicide, together with constant observations or high levels of intermittent observations, placed an extra burden on detention staff. The workload on DCOs working on the wings and those working in reception was, you may think, consequently often unmanageable. The responsibilities of DCOs working on the wings were wide-ranging. They were responsible for a number of tasks, including admitting detained persons to the wing, as I've said, making observations on detained persons subject to ACDT, as well as completing ACDT observation forms, making property appointments, handing out essentials like toilet roll and soap, checking detained persons' cards as they try to access the wing, allocating detained persons to rooms, resolving disputes, responding to incidents of violence or self-harm on the wing, escorting detained persons to the kitchen to work and collecting the food trolley from the kitchen. DCOs on the wing were stretched and they were overworked, resulting in them being unapproachable and exhausted. You may wish to consider whether this may sometimes have led to some staff taking their frustrations out on the detained men. In May 2017, something I've already alluded to, an additional 60 beds were introduced into Brook House. This meant that some rooms with a bunk bed and single bed were shared by 3 men. The staff levels were reported, however, to remain the same, which appears to have created further strain and affected morale. Overcrowding was reported to impact access to healthcare, solicitors' appointments and welfare, with long waits being common. There were often admissions of a number of detained men at a time, sometimes late at night or in the early hours of the morning. On occasions, no interpreters were available. You'll hear evidence that detained persons were often confused, frightened, and distressed on reception. You may conclude that an unmanageable workload resulted in detained persons waiting for long periods in reception before undergoing first reception screening and admission. You may wish to consider whether a lack of staff also meant that the needs of detained persons were not adequately met at times, staff members weren't able to identify problems in their lives or areas in which they could be helped. Detained persons sometimes couldn't access cleaning materials or the laundry room when they needed it, or obtain access to recreational areas, whether outside or in the centre or the library or the IT room, to work on their cases. The range of activities available was reduced due to activities staff covering gaps in staffing on the residential wings. An associated problem with a high turnover of staff and significant difficulties in the recruitment and retention of staff members. This was the case in relation to both detention and healthcare staff. You'll hear evidence that often detention staff were inexperienced and left quickly after joining. Many felt unprepared and ill-equipped to deal with the challenging environment of Brook House. Some felt undervalued by management. In healthcare, many of the staff were agency staff, and there were vacant permanent positions despite several recruitment drives. You may want to consider whether the range of staffing problems described contributed to dissatisfaction among detained persons and a growing feeling of hopelessness and frustration among them, which in turn had an impact on the levels of self-harm, substance misuse, and violence at Brook House. The more challenging or non-compliant detained persons became, in consequence of their environment, the more some staff resented them for the additional work and stress this added to their lives. Understaffing and overwork was also reported to affect staff morale in a direct sense. The management of healthcare and delivering of clinical care to detained persons in Brook House presented its own challenges. The evidence from formerly detained persons raises concerns that a culture of disbelief persisted in healthcare, with doctors and nurses being dismissive of detained persons and exhibiting a lack of care or empathy, and a potential to believe that a patient was exaggerating their symptoms, conditions, or past history for the purposes of furthering their immigration case. The evidence from some healthcare staff, detention staff, and formerly detained persons reveals that the problems with understaffing, resourcing, staff recruitment, and staff retention may have impacted upon the ability of healthcare staff to deliver adequate healthcare to detained persons on occasions. It was a difficult time within healthcare during the relevant period, which impacted particularly on the reception of detained persons into Brook House, where it was reported by some detention staff that healthcare staff were run off their feet. Detention staff experienced frustration caused by difficulties in getting hold of healthcare staff. Additionally, where an incident needed a medical emergency response, 2 members of the healthcare staff were required to respond, which sometimes took a member of reception staff away from first reception health screening. This would leave detained persons waiting in reception, causing frustration and disruption. Detained persons were often not seen within the required 2-hour timeframes, and their admission was therefore unduly delayed, sometimes by several hours. Healthcare staff fulfilling roles related to Home Office requests concerning immigration requirements, such as writing fitness to fly letters, also sometimes placed pressure on resources and resulted in disruption to the provision of clinical care. Where there were pressures on staffing in one area, such as admissions into reception, another area such as the triage clinic might suffer. And there were aspects of healthcare staff's roles in which they felt unsupported by detention staff, such as when DCOs were not available to escort nurses providing medication at night. You may want to consider whether the BBC footage relating to healthcare incidents, primarily showing healthcare staff's responses to medical emergencies, either involving serious incidents of self-harm and attempted suicide or intoxication, reveals overall an adequate immediate emergency medical response and competent clinical practice on attendance. What is clear, though, is that self-harm and intoxication with spice or other drugs, and spice is a psychoactive substance and a synthetic cannabinoid, were significant issues presenting difficult challenges for healthcare staff, and that the systems in place for the management of these vulnerable detained persons were not addressing the underlying causes. This resulted in significant diversion of staff and resources to medical emergencies away from other patient care and processes, such as assessments under Rule 35 of the Detention Centre Rules of 2001, to which I now come. Rule 35, subsection 1, so Rule 35.1 of the Detention Centre Rules requires there to be a medical practitioner's report to the centre manager where a detained person's health is likely to be injuriously affected by continued detention. And Rule 35, subparagraph or subsection 3, Rule 35.3, requires there to be a separate report where there is concern a detained person has been a victim of torture. Analysis of the evidence available to the inquiry reveals several areas of concern. Issues of understaffing and overcrowding meant that there were sometimes long waits for Rule 35 assessments. There are numerous complaints from formerly detained persons concerning the reporting of suicidal thoughts or serious attempts at self-harm or suicide, where there was no consideration given to the completion of a Rule 35 report. Several formerly detained persons recall reporting being a victim of torture to the nurse on first reception health screening, or to a mental health nurse having presented with symptoms of depression, anxiety, or post-traumatic stress disorder, PTSD, where no referral to a doctor was made and no Rule 35 assessment carried out. Of the 76 Rule 35.3 reports completed in the relevant period, analysis by Dr. Hard suggests that the majority of them, just over 75%, were completed inadequately in that no conclusion was reached as regards the possibility of previous ill treatment, or in the vast majority of these cases because no conclusion was reached as regards the impact of ongoing detention. It's also troubling that despite the requirement to complete a report under Rule 35.3, where there was concern a detained person had been a victim of torture, and a separate report under Rule 35.1 in the case of a detained person whose health was likely to be injuriously affected by continued detention, there were only 2 Rule 35(1) reports completed during the relevant period. You'll hear evidence to suggest that there was no system in place to allow for quality audits of Rule 35 reports by the Home Office policy team, despite this being raised by the head of healthcare with the Home Office. Further, the system doesn't appear to have been operating as intended, with a large number of positive Rule 35(3) reports not resulting in a release from detention of the detained person. The inquiry has seen Rule 35 reports where the doctor's conclusion was that the detained person had likely been a victim of torture and/or continued detention was likely to be injurious to their health. But only 27% of those cases led to release from detention. Given what is known of the prevalence of serious self-harm and suicide attempts during the relevant period, you may wish to consider whether it's surprising and indeed concerning that there were no reports completed during the relevant period under Rule 35, which provides for a report to be made to the manager in the case of any detained person suspected of having suicidal intentions. That's Rule 35(2). There doesn't seem to have been any system of referral of a detained person to a GP, or any member of detention or healthcare staff had concerns that he was suicidal, whether due to responding to a suicide attempt or an incident of serious self-harm, or because the detained person reported suicidal intentions. No such referral was made on the opening of an ACDT, for example. It appears it was left to the detained person to request such a report. The responsibility of a GP completing a Rule 35 report creates an inevitable tension between the forming of a doctor-patient relationship with the detained person, allied with the provision of medical care on the one hand, and on the other, the requirement for an analysis of the available evidence in order to determine whether a detained person had been a victim of torture. The latter role was not one typically undertaken by medical professionals, and in particular GPs, as part of their usual responsibilities. This type of analysis of evidence and coming to conclusions about its cogency was an alien exercise for GPs, and in the absence of a specific, detailed training on how to undertake this task, was one which you may think they were ill-equipped to carry out. Some healthcare staff reported that the lack of formal staff induction didn't prepare them for their role in Brook House, and that the training provided was insufficient in various areas, such as control and restraint, the ACDT process, suicide prevention, safeguarding, adults at risk, and substance misuse. Rule 35 and its operation at Brook House during the relevant period will be covered in detail by Dr. Hard during the course of his evidence. Let me put up on screen two examples of reports issued by medical practitioners in Brook House during the relevant period. One is a report under Rule 35(3) of the 13th of April 2017 regarding concerns that a detained man, D2567, may have been a victim of torture, and the other dated the 17th of July 2017 in relation to D1914, whose continued detention was regarded as injurious to his health. So can we put up on screen first, please? CJS 000872 at page 1. And here we have a Rule 35 3 report. You can see at the top, it's got the Home Office logo, top left. Removals, Enforcement and Detention Policy, Immigration and Border Policy Directorate is the heading. Annex C. It cites the Detention Services Order 9/2016, Detention Centre Rule 35, and this in particular is a Rule 35-3 report. Concerns that a detainee may have been a victim of torture. Section 1 provides the detainee's details, D2567. Immigration Removal Centre, Gatwick Immigration Removal Centre, and under Section 2, we have detainee's authority to release medical information. Section 3 is the medical practitioner's report. I've examined the detainee named above in my capacity as an Immigration Removal Centre medical practitioner and hereby report that I have concerns that the detainee may have been a victim of torture. This is a factual report rather than a medico-legal one, and then sets out the medical practitioner's understanding of what torture means in this context. And then under Section 4, next page please. Please provide details of the account given to you by the detainee of the alleged torture, providing as much detail as possible about the detainee's explanation for the cause of each injury, scar or symptom, and details of when, where, how, and over what time frame and why the torture is said to have happened. And then you have, in this man's case, the medical practitioner's history taking. Says he informed the Home Office on the 1st of April of his torture, escaped Mosul, made his way to Turkey, made to be a slave for 3 years in Turkey for a Kurdish mafia group who'd beat him with wood to the back of the head, gave details about what happened to him sexually when aged 13, had tried to kill himself in Turkey once and twice in this country. In the IRC, in other words, in the Immigration Removal Centre, becomes tearful, explains he walks around ashamed, thinking that others will know all about him, wants to die, feels no one cares about him, no place for him, difficulty sleeping, has events going back to events from 2008 when he was 13, and having been physically attacked 2 months previously in Dunkirk by a group of random men who hit him to the back, but no scars present, and so on. Section 5 on page 3, relevant clinical observations, details required, appears vulnerable, has some scarring to his foot, no other marks. In addition to the scars he's mentioned, has also evidence from self-harming in early April, whilst at the IRC, seen by medical health team, difficulty sleeping, displays symptoms of depression, general low mood. And then section 6 on page 4. I wonder if we could zoom in just a bit, please, on these pages. Thank you. Set out reasoned assessments of why, on the basis of the detainee's account, together with your own examination and clinical findings, you're concerned the detainee may have been a victim of torture. And in the final paragraph, he describes a 3-year period of slavery with periods of physical and sexual abuse and torture. I think there is a strong likelihood of torture and deterioration in this environment. Note self-harm, appears a credible individual. His scars are consistent with his account, despite paucity. So that's that one, just by way of example, as a victim of torture. And if we can take that down, please, and go to another one, CJS 001024 at page 1. And same title at the top. This is in relation to D 1914, again at Gatwick Immigration Removal Centre. And we have Section 2, consent. Section 3, the medical practitioner's report. I write in respect to the detainee named above, which seems to be a pro forma, this being a report of a detainee whose health is likely to be injuriously affected by continued detention or the conditions of detention. Page 2, if we may, please. Zoom in at the top if you would. Can you scroll down? Thank you. Section 4, relevant clinical information. This man has had 2 myocardial infractions, 2 coronary arterial bypasses, currently awaiting cardiac catheter ablations for abnormal cardiac rhythm. Intermittently complained of chest. During his stay in detention, recently sent to A&E as healthcare felt he had acutely deteriorated, felt he is a high-risk patient in view of his medical condition, and that though detention is not worsening his condition, the stress may trigger events that lead to another cardiac event. And then the treatment he was receiving under Roman 2, he's awaiting cardiac catheter ablation, next appointment with cardiologist, 18th of August, a hospital outpatient appointment. Under Roman 3 at the foot of the page, asked about mental health problems, there are none. And then on the next page at the top, section 5, page 3, what impact is detention or the conditions of detention having or likely to have on the detainee's health, and why, see above. Ongoing stress and the unstable nature of his condition put his health at risk. 2, can remedial action be taken to minimize the risks? No. If the risks to the detainee's health are not yet serious, Roman 3, are they assessed as likely to become so, etc.? Not possible to quantify this, but it is felt that he appears worse in health than during the early part of his detention. How would release, Roman 4, from detention affect the detainee's health? It suggested release would reduce his level of stress, which may reduce the risk. 5, are there any special considerations that need to be taken into account if the detainee were to be released? Don't know. So those are but 2 examples of 2 Rule 35 reports under the separate provisions in which medical practitioners at Brook House provided those reports. Let me move on. Drugs misuse. During the relevant period in Brook House, there was what has been referred to by some as a spice outbreak. There was prolific use of spice among detained persons at this time, and there was a significant number of incidents involving drugs, including medical emergencies where healthcare staff were required to respond urgently to incidents of detained persons becoming intoxicated and unwell. We can take this document down, thank you. As I have mentioned before, medical emergencies resulted in the significant diversion of staff, both detention and healthcare, and resources away from other duties. For those detained persons who were vulnerable, the prevalence of drugs and the level of intoxication created a frightening and unpredictable environment in which their general welfare would undoubtedly have suffered. It also provided an opportunity for some detention staff to show what you may think to be their disdain for the detained person. One such instance was that in the case of D1275, who on the 14th of June of 2017 was filmed by Callum Tully suffering a spice attack. He was attended to by healthcare, but he was mocked by both Nathan Ring, at the time a detention custody manager, a DCM, and a DCO by the name of Derek Murphy. Ring made a series of comments, including "keep still, you div." I should have said, quote, "keep still, you div," end quote, quote, "scrotum," end quote, quote, "leave him," end quote, and quote, "bucket of cold water will sort out his heart rate. That would do him the world of good," end quote, and mocked D1275 for his singing. DCO Murphy said of D1275, quote, "look at the state of that," end quote, quote, "imagine bringing that home to mother," end quote, and perhaps more chillingly, quote, "absolutely no sympathy for them at all. If he dies, he dies," end quote. There are allegations of staff bringing in drugs to Brook House, as well as drugs coming in through the visitors' hall, with apparently little training or guidance given to staff in how to prevent the smuggling of drugs into the centre, and little action taken by management to address the issue or the underlying causes. The use of force. The use of force is an issue of great importance to this inquiry. The term use of force has a particular meaning in the immigration detention context. According to the Detention Services Operating Standards Manual for Immigration Removal Centres, quote, "force is used only to keep a detainee in custody, to prevent violence, to prevent destruction of the property of the removal centre or of others, and to prevent detainees from seeking to prevent their own removal physically or physically interfering with the lawful removal of another detainee," end quote. Force in this context can embrace many types of physical contact. It can include restraint, holding down, separating, physically moving, pushing, pulling, handcuffing, frog marching, and so on and so forth. The so-called minimum auditable requirements for the use of force, as described in the Detention Services Operating Standards Manual, according to the relevant page of the manual, apparently issued in December 2002, are that 1, the centre will ensure that force is used only in the circumstances I've just described, as quoted. 2, force is only to be used as a last resort and strictly within the terms of Rule 41 of the Rules of 2001. Rule 41 provides that a DCO shall not use force unnecessarily, but where the application of force is necessary, no more force than is necessary shall be used. It also provides that no officer shall act deliberately to provoke a detained person. Moreover, particulars of every case of use of force have to be recorded by the manager and have to be reported to the Secretary of State. Third, if handcuffs are used as part of the use of force incident, separate guidance under the Detention Services Order 1 of 2002 must be adhered to. Fourth, the centre must use and purchase training for control and restraint, also known as C&R, techniques from the prison service, with advanced training being carried out by the prison service and basic training by the centre's own instructors, provided they've been trained and certified by the prison service. Fifth, the use of force must only be applied by members of staff who've undertaken necessary training. Sixth, if use of force is used, the centre must ensure that detainees are seen by a member of the healthcare team as soon as practicable. And seventh, the centre must have a system for recording all incidents of use of force and to monitor its use. The inquiry has received and analysed a wide range of documentation concerning each of the 109 use of force incidents recorded by G4S officers as have occurred during the relevant period. The documentation which has been provided by G4S and analysed consists of a vast array of material. And just let me describe what that is. Use of force forms completed by DCOs, which provided accounts of what happened, reports of any injuries sustained during the incident, detainee debrief forms, electronic logbooks in which G4S recorded and summarised each incident by month, use of force review meeting forms, which are handwritten single-page forms in which DCM Steve Webb, who was a C&R, a control and restraint instructor, reviewed the documentation for each use of force form. Oscar 1 diaries. Oscar 1 was the detention custody manager, the DCM, who had responsibility for the daily running and management of Brook House. These are handwritten handover logs, providing very brief descriptions of notable events each day and evening. There were security and use of force meeting minutes, consisting of PowerPoint presentations and statistics concerning, among other data, use of force incidents. Complaints by detained persons, notes from IMB visits, Professional Standards Unit, the PSU documents, G4S investigation documents, and training records. The reviews conducted by DCM Steve Webb require special mention. They were conducted 2 months after each use of force incident. Having found there to be many missing review meeting forms, the inquiry was told by G4S that use of force incidents were not reviewed at all after September 2017. In other words, for those incidents occurring in June 2017, since those conducting the reviews had been suspended or sacked and were not subsequently replaced. As a sample, a use of force review meeting form concerning a detained man, D149, is an example of what could literally be characterized as a tick box exercise. We'll be hearing more about these reviews from Mr. Collier in phase 2, but as a sample, let me ask the evidence handler please to put up on screen CJS 000901 at page 1. And if we can just scroll it down ever so slightly, please, so we can see the top, thank you. Headed Official Sensitive, G4S logo on it, use of force review meeting form, detainee name, ciphered as D149, some reference numbers, date of review, 21st of July, name of person completing review, Steve Webb. And running from the left column down, are all of the use of force reports present? Tick yes. Are the documents completed correctly and to an acceptable standard? Ticked yes. Does the incident meet the following criteria? Reasonable in the circumstances? Yes. No more force than is necessary? Yes. The outcome of this review, further investigation required? No. Letters of commendation required? No. And moving to the top right, is the F213 medical form present? Yes. And that would typically be a body map type form. Is there CCTV, body-worn camera, BWC, or camcorder evidence which covers this incident? Yes. And then necessary, I suppose one should read this from the top box left to right, and then the bottom box is left to right. But necessary, which is one of the criteria. Was it necessary? Yes. Proportionate to the seriousness of the situation? Yes. And as part of the outcome of the review, lessons learned and further training? No. Action further required? No. So that is a typical form, and at the bottom we can see that Mr. Webb has signed it, and as we saw, it's dated the 21st of July 2017 in this instance. The delay in reviewing use of force incidents gives rise to two principal concerns. One, that recollections are likely to fade over the time it took to review these incidents, and second, that if reviews were not timely, inappropriate behaviour might be repeated without review or sanction for a long period. It's troubling that for over half of the relevant period, use of force incidents were not being reviewed at all. In addition to the documentary material I've listed, there is of course the BBC footage, which includes footage that was broadcast on the Panorama programme, and unbroadcast footage, and it includes, as I said before, Callum Tully's video diaries. The inquiry has also received footage from G4S captured by body-worn cameras, occasionally worn by the officers and by CCTV operating at Brook House. As you know, Chair, the inquiry has appointed Jonathan Collier, an expert on the use of force, to assess the evidence, and Mr. Collier has been asked to provide his expert opinion on 43 key incidents, whether the force used was reasonable, proportionate, and necessary. Now, before we break, let me at least start by outlining the complaints process. The policy requirements on handling complaints within immigration detention centres such as Brook House are set out in the Detention Services Order 3 of 2015. Complaints could be made by detained persons by various means, including verbally to a member of G4S or Home Office staff, to a member of the IMB, or by putting a written form into a yellow box at the centre. Additionally, people not in detention, such as friends or family members, NGOs and solicitors, could raise concerns in writing with G4S or with the Home Office. Part of the Home Office's contract monitoring role involved ensuring that complaint forms were available in every residential unit and in the library, and they were translated in up to 20 languages. According to G4S Care and Justice Services corporate statement, all detained persons had access to the Home Office complaint system, and anyone could complete a complaints form and post it in the Home Office postbox on each unit. Once a complaint was made by a detained person, it was the Home Office's role to collect forms from the locked boxes each morning and pass them on so that they could be distributed to the correct place. They'd be received by the Detention and Escorting Services, the DES Complaints Unit, who would filter them based on the seriousness of the complaint, making a decision about whether it should be investigated by G4S, the Home Office PSU, the Professional Standards Unit, or indeed by NHS England. The PSU is part of the Home Office, but it sits within a different directorate to Detention and Escorting Services and Immigration Enforcement. Mark Hartley King, the Assistant Director assigned to the PSU at the relevant time, says that this helps to ensure the independence of the PSU from the DES, from the Detention and Escorting Services part of the Home Office. Allegations of minor misconduct or about conditions or facilities within Brook House would be investigated internally by G4S. They would usually be allocated to a senior manager who would then ask a DCM, a detention custody manager, to investigate. This might include interviewing the detained person who made the complaint, any relevant staff or other detained persons, and viewing CCTV or other evidence. Ultimately, a letter was then sent to the detained person setting out the findings in response to their complaint. These responses would be dip sampled by the Home Office on a monthly basis to assess quality. Although there was a 20-day turnaround time for complaints, staffing pressures meant that managers had fallen behind by as much as a month. G4S's requests and complaints policy in force during the relevant time provided that a complaints coordinator would maintain a register of written complaints and the outcome of them. The policy also required a monthly complaints report to be compiled, informing senior management of all the complaints received during the previous month and offering comparisons on a quarterly basis for trend analysis purposes. This report was required to detail the nature of the complaints, their outcomes, which areas actioned the investigations, their categories, and the nationalities of the complainants. It doesn't appear that monthly reports were produced during the relevant period. Allegations of serious misconduct against G4S or Home Office staff should have led to a PSU investigation, and this could be commissioned immediately after the complaint or incident or could follow an initial G4S investigation. However, the inquiry is aware of at least 2 instances where complaints were not passed to the PSU in a timely manner in relation to one complaint, a complaint by D2953 and a complaint by D1538, more of which, with your permission, at 2 o'clock. Chair.
Thank you very much. Yes, we'll return at 2 o'clock. Thank you, Mr. Rotman. Thank you. Welcome back.
Chair, before we broke, I was dealing with the issues of complaints, and I had told you that the inquiry was aware of at least 2 instances where complaints weren't passed to the PSU in a timely manner. One of those was in relation to a complaint by a detained person ciphered as D2953. In his case, he had contacted G4S's Equalities Advisory Support Service by telephone on the 10th of June of 2017 and made further calls, including on the 16th of June when he stated he'd been assaulted 3 times by a staff member. D2953 said that he was at Brook House, but for whatever reason, the helpline didn't know that G4S ran Brook House. And during one call, the helpline operator asked him if he wanted her to notify someone in Brook House about what was happening to him, but this was never followed through. Excuse me. The matter ended up being recorded as a whistleblowing issue on the 24th of September, some 3 months after, and it was initially allocated for investigation by G4S. Even at that stage, it was not referred to the Home Office on the basis that there was, quote, no evidence that an assault had taken place, end quote. By the time it was referred to the Home Office, and then the PSU on the 13th of November, it was already being investigated because a separate complaint had been made by D2953 solicitors in a letter before action of the 28th of September 2017 addressed to the Home Office. In an email of the 14th of November 2017, Mark Hartley King, someone to whom I've already referred, he at the time was an assistant director assigned to the PSU, wrote, quote, the way things are being mishandled at Brook is not great, end quote. D2953's complaints were in fact substantiated, and the PSU reached the conclusion that he had been assaulted on 3 occasions by a G4S staff member, Derek Murphy. And I'm going to ask to be put up on screen some pages of the PSU investigation report. Let's begin with the title page, which is CJS 001506 at page 1. Forgive me, it should be at page 20 of this this document. It's page 20. So for the first page of the investigation report, the title page. There we have it. Home Office Security Professional Standards Unit, a Home Office investigation into the circumstances surrounding the treatment of D2953, who states he was assaulted by DCM Derek Murphy on the 10th, 11th and 12th of June 2017 whilst at Brook House. And we can see who the investigating officer was, Rukhsana Rafiq. And if we then go, please, within this document to page 32, and if we just scroll down to the bottom half of the page, consideration of evidence and conclusions, allegation 1, on the 10th of June, DCM Murphy hit him hard on his left thigh, leaving a bruise. On the 11th of June, punched him on the chest, lower abdomen, and on the 16th, punched him on the left side of his head. And those were the allegations that were made, consolidated into one allegation. We can see the report then continues with a review into D2953's complaints. I'm not going to go through that now, but if we go on, please, to, I think, what would be page 35. At 7.2, we have the conclusion. Crucially, some of this mistreatment by acting DCM Murphy was around the same time, and that's a reference back to evidence that Mr. Murphy had been interacting with other detainees in not dissimilar fashion, as when D2953 alleges he was mistreated by Officer Murphy. Balance of probabilities, which is the test applied, it's therefore right and proper for this investigation to attach weight to the information contained within the Panorama programme when assessing D2953's allegations against Murphy. And on it goes, and then over the page, please. To what should be the next page, please. And you scroll up. Paragraph 7, 2.4, in bold, therefore on a balance of probabilities, conclusion reached, there is substance to the allegations, consequently the allegation is substantiated, and then we can see, thank you, that it's followed by recommendations. So that is the format of PSU investigation reports. I'm only bringing this one up as a sample, but referable to the case which I was just describing. Thank you, that can go down. On each occasion when a complaint is passed to the PSU, an investigating officer will be allocated, that can come down, thank you. An investigating officer will be allocated who bears responsibility for carrying out the investigation. Their role will be to gather relevant evidence, including interviewing the complainant, ideally in person or alternatively by phone or via their representatives, obtaining relevant documents, such as use of force reports or medical records, obtaining relevant footage, such as CCTV or body-worn camera footage, and interviewing the staff who are subject to the complaint and any relevant witnesses. As provided in the Detention Services Order 3 of 2015, when dealing with allegations of serious misconduct, the PSU had to provide a substantive report within 12 weeks. There are several occasions in which this target doesn't appear to have been met. Even when a complaint is withdrawn by a detained person, the investigation should continue to a conclusion unless the detained person has explicitly asked for it to stop. There have been 3 withdrawals from PSU investigations into Brook House since 2012. The PSU's evidence suggests that any allegation containing an element of criminality is referred to the local police if this had not already happened, such as in cases where there is an allegation of assault. Although there is evidence of this having happened in some cases, it didn't appear to happen in every case. Police investigations can proceed in parallel to or take priority over PSU investigations. But in several cases, the evidence suggests that police waited for the PSU to complete its investigation before deciding whether to take any further action, such as in D2953's case. The investigating officer will produce a report summarizing the allegations, the evidence gathered, findings and recommendations, as we have just seen. Ultimately, it's for the investigating officer to come to a conclusion in relation to each allegation as to whether the available evidence substantiates the complaint, again as we saw on the balance of probabilities. However, the case will be reviewed by a senior investigating officer also. A response letter in similar but not exactly the same terms as the report will be sent to the complainant. Chair, you may want to consider some of the weaknesses identified in relation to the complaints process during the relevant period. They include the lack of process at the time for recording and tracking informal complaints, the perception that complaints are submitted to the Home Office and referred to G4S for investigation, deterring people from raising complaints, quote, due to potential repercussions or lack of credible investigation, end quote. And that comes from the witness statement of Michelle Smith, from whom we will be hearing early next week, but in relation to scene setting only. Or third, the spreadsheet recording all complaints containing or relating to allegations of misconduct by staff didn't include or cross-refer to allegations which had not been the subject of a formal complaint, but had come to light via the security incident report, an SIR process, use of force reports, HR reports, or any other way. Once a PSU investigation has been completed, it's for the Home Office to consider the findings and any appropriate action. This may include consultation with senior management at Brook House, where allegations against staff are substantiated by investigation. The matter is referred as appropriate to the G4S Centre manager, head of healthcare, or appropriate Home Office line manager to consider action. Many PSU investigations were commissioned specifically to include the identifications of lessons to be learned and recommendations. And some of the recommendations in reports seen by the inquiry include individual training for specific officers, the need for staff to be reminded of their responsibility to respond to and document all complaints raised to them by detained persons, addressing concerns held by detained persons about using the formal complaints process, and discussing with them about why they don't formally complain, the need to activate body-worn cameras, the need for Home Office staff at Brook House to ensure that during their contact with detained persons, any serious allegations and complaints are identified, the need for Home Office staff to monitor body-worn camera footage and observe incidents and planned use of force, the need to recall all use of force, reminding all staff of the actions to be taken when a detained person alerts them to any form of mistreatment, and for G4S to review and ensure that their complaints handling process is robust enough to prevent a similar situation as happened in D2953's case from happening again. Prior to the relevant period, other recommendations included reminding staff of the need to report inappropriate conduct, that was in 2012, and the need to report alleged assaults, 2015. There appears to have been a team within the Home Office whose mailbox address was detention ops lessons learned at homeoffice.gsi.gov.uk, who were responsible for ensuring lessons were learned from investigation reports and for monitoring the implementation of recommendations from the Prisons and Probation Ombudsman and other oversight bodies. Chair, you may want also to consider the extent to which these many recommendations were heeded and in some cases whether a quicker investigation process may have led to action being taken at an earlier stage which could have prevented subsequent mistreatment. I should also add that there was a separate complaints process for investigating complaints about healthcare provision or the conduct of healthcare staff, whereby those complaints would be investigated by G4S Healthcare or NHS England. And of course the PPO's office, of which you will be well aware, also had a role in terms of hearing appeals arising from complaints in immigration detention. We're going to hear more about that in phase 2. In response to the Panorama programme, the Home Office initially chose to rely upon a G4S-led investigation into the relevant staff members. However, in October 2017, litigation was initiated on behalf of some detained persons in relation to allegations of abuse and procedural failings at Brook House. This led in November 2017 to the PSU being commissioned by the Home Office for a specific investigation into 10 claims stemming from Panorama. Let me now come on to monitoring and compliance. Assessment of G4S's performance relied upon engagement with detained persons, analysing data such as staff attendance, Rule 40, which is removal from association, Rule 42, temporary confinement, documents, use of force reviews, speaking to staff and carrying out checks on things like the cleanliness of the centre and dip sampling complaints responses. However, there was a lack of capacity to undertake contract monitoring within the on-site Home Office team, and performance measurements relied very heavily on self-reporting by G4S of any service failures, which would be added to any performance failures identified by the Home Office and inserted into a so-called mitigation log. Chair, I'm being asked to pause for a few minutes because there is a transcription issue.
Okay, thank you. Yes, we'll take a break for 5 minutes. Thank you. Return at 2:25 past. Thank you. My apologies for the pause, but I think we're back up and running.
Sort of.
Okay. I'll let you fill in the details.
Chair, my understanding is that there have been, as I think most people know, there have been Wi-Fi issues. And apparently the transcription service over here, which relays to some of those screens over there and perhaps screens around me, is not working as it should be. And I understand that's a Wi-Fi issue. If that issue persists, any missed parts of my opening can be provided to those who are interested in having it during the course of the afternoon or perhaps later, but hopefully the whole transcript will be on the website later this evening in any event. I think I've understood it correctly.
Thank you.
So, let me just rewind. I was dealing with monitoring and compliance, and I told you, Chair, that there was a lack of capacity to undertake contract monitoring in the on-site Home Office team, and that performance measurement relied very heavily on self-reporting by G4S of any service failures, which would be added to any performance failures identified by the Home Office and inserted into a so-called mitigation log. That's where I'd finished. Now, according to Alan Gibson, who was head of operations, formal monitoring focused mainly on staffing levels, measured in hours, declared by G4S. Ian Castle, the detention and escorting service manager for Gatwick Immigration Removal Centres from July 2017, admitted that they probably didn't go beyond contractual obligations to determine whether Brook House was a good enough place. I should have said, quote, a good enough place, end quote, or quote, being well enough run, end quote, or whether, quote, the experience of detainees was good enough, end quote. We understand that the process for monitoring performance included weekly meetings for both sides to raise issues or failures, monthly meetings to discuss penalty points, and quarterly meetings focused on long-term commercial aspects of the contract. Any failures would be inputted into a spreadsheet and then addressed during weekly meetings between the Home Office and G4S, taking into account any mitigation put forward for a breach. However, we have not seen minutes for these weekly meetings. Details of penalties imposed under the contract included regular performance management reports written by G4S. We've received reports relating to each month of the relevant period. Some of the notable findings are, in April 2017, there were reported to be no serious complaints, which was a term of art, and one other complaint, another term of art, about handcuffs not being properly applied during escort to hospital. This was the month during which Panorama showed a number of serious incidents, including the incident involving D1527 and a DCO about whom we will hear more, Jan Pascali. In May 2017, there was one reported serious complaint relating to a detained person who said he left Brook House without his bag of property, and 4 other complaints, all of which were fully or partially substantiated, and included an allegation of a detained person being verbally abused by a member of staff, and an allegation from 2015 regarding medical confidentiality. In June 2017, there were 2 apparently serious complaints, one relating to a detained person who was transferred and didn't get his boots, and the other relating to a detained person who didn't receive cash sent to him. The only other complaint noted was about an absence of cleaning products. In July 2017, there was one serious complaint about property having been left behind, and 2 other complaints about meals and payment for work. And in the final month of the relevant period, August 2017, there were 2 serious complaints, one about a detained person not being paid for work, and another about a detained person not being let out of his room on 2 occasions to carry out his cleaning duties and being called being called an inappropriate name by an officer. The one other complaint related to a detained person's visiting partner not being allowed to breastfeed. Chair, in light of the number of incidents and complaints about which you will hear evidence, you may want to consider why only these few matters were identified and recorded for contractual purposes during the relevant period. You'll also note that the vast majority of events which are identified as untoward or so-called untoward events appear to relate to failures to produce a detained person for an official or legal or case-related visit within 15 minutes. In addition to this regular monitoring, the Home Office's Detention and Escorting Assurance and Audits Team, here's another acronym, DSAT, D-E-S-A-A-T, undertook contract compliance checks twice yearly and carried out thematic reviews on specific topics. At a more senior level, a formal executive oversight board was held by the Home Office every 3 months to discuss contractors' performance, chaired by a senior civil servant from the Home Office Commercial Directorate, and it was attended by Immigration Enforcement. According to Ian Castle, in late 2017, early 2018, quote, a new method of measuring contract compliance was introduced by the Home Office, and that staff were given specific areas to monitor, including reception or induction process, detainee welfare, catering, cleaning, among others. The team met on a monthly basis to discuss any issues, particularly those that were not being addressed. Care and welfare was considered particularly important by the Home Office, and Home Office staff attended weekly detainee welfare forums. Well, let me come on now to senior management team and security team meetings. At a senior management team meeting, or at the acronym being SMT, in June 2016, under the heading of Audits and Compliance, and following the entry updated on penalty points, it was noted that there was an appeal against the outcome of 2 PSU complaints. This might suggest, at least at this time, G4S had been penalised under the contract for conduct, which led to a PSU complaint being upheld. However, we've not seen any evidence as to whether there were any such penalties during the relevant period. Similarly, in a December 2016 meeting, it was noted under the Audits and Compliance legend that, quote, 2 incident reports for UOF short for use of force, were not submitted within 24 hours, with one offering no mitigation and the other was down to confusion as whether, is the way it reads, as whether it was a UOF, end quote. Performance management reports provide evidence that penalty points were awarded for late submission of use of force documents. One example falls just outside the relevant period in the month ending November 2017. However, in the relevant period, in the months ending April, May, June and July 2017, no points were awarded for late submission of use of force reports. In the month ending August 2017, points were awarded for what appears to have been late delivery of an incident report, which included the use of force on a detained man, that was D 1249, on the 11th of August. The Home Office didn't accept G4S's attempt to mitigate the points awarded. During a senior management team meeting in October 2016, Mr. Saunders, the then Centre Director, noted that there was a need to make sure that DCMs were aware of the contract requirements to try and alleviate failures and penalty points. During another senior management team meeting, this time in April 2017, Mr. Saunders noted that this was the last year of the contract and that the Home Office were pushing back on the mitigation that G4S were offering against penalties for performance failures. At a security, as distinct from senior management team, but at a security meeting in September 2017, Barry Timms, the Audit and Compliance Manager, noted that, quote, staff don't understand what failures are subject to penalty points, end quote, and pointed to an inability to mitigate repeated incidents, rising failures relating to escort paperwork and failure of an escort, and there were heavy penalties relating to the IT suite. Now, Chair, moving then away from those issues, let me now please set out some facts and figures under separate heads. First of all, the detained population. As you appreciate, Brook House held men detained under immigration powers from all over the world. During the relevant period, records provided to the inquiry show that the most common countries of origin of those detained at Brook House were, in order, India, Albania, Pakistan, Nigeria, and Bangladesh. During the relevant time period, monthly statistics show that the average population varied from 435 to 465 men, with an average occupancy of 446 in detention over the period. On average, 35% of those detained at Brook House were time-served foreign national offenders, TSFNOs, those who had completed sentences of imprisonment and were in detention awaiting deportation. Staffing levels. The terms of the contract, as originally agreed between G4S and the Home Office, provided that where centre capacity was 91 to 100%, between 8 a.m. and 9 p.m. there should be 3 DCMs and 35 DCOs on duty, 34 at the weekend. And between 9 p.m. and 8 a.m., 2 DCMs and 11 DCOs on duty. During the relevant period, the contract between G4S and the Home Office stipulated that 668 hours of DCO time should be provided each weekday, 655 at weekends. And it required at least 2 DCOs to be on duty on each residential wing during the day. It's believed that the contractual specifications had moved away from the number of staff on duty as originally contracted to the number of staffing hours during the relevant period. At full capacity, and following the increase in bed numbers in May 2017, when 60 rooms, you'll remember, were converted into triple occupancy, a wing could house up to 150 men, meaning a ratio of 1 DCO to 75 detained men, if both DCOs remained on the wing. During the relevant period, there were 13 days on which the minimum DCO staffing level wasn't met. All of them were between June and August, and almost always during weekends. On 4 occasions, staffing was 90% of the minimum level or below. Let me return to contract points deductions. Over the life of G4S's contract with the Home Office, deductions represented on average around 1.5% of the monthly fee. Between April and August 2017, G4S incurred 19,245 penalty points under the terms of the contract, amounting to a financial deduction of £32,153.84. During the period, neither verbal abuse of a detained person nor inappropriate use of force constituted performance failures. Review of the BBC panorama footage by G4S and the Home Office led to the identification of 84 incidents, most of which had been reported under the contract or were not reportable events under the contract. G4S was charged £2,768 by the Home Office in respect of 8 of these incidents. An investigation by the National Audit Office published in July 2019 concluded that until 2018, the Home Office didn't have the people in place properly to verify or validate G4S's reported level of performance, echoing Alan Gibson's account of a lack of capacity to undertake contract monitoring within the Home Office on-site team, so that performance measurement relied, as he put it, very heavily on G4S self-reporting service failures. The National Audit Office noted that quote, the on-site monitoring of G4S's contractual compliance was part of one executive officer's role, a junior civil servant who sat in the detainee casework team and focused mainly on monitoring G4S's level of staffing. This was insufficient to enable the Home Office to properly examine G4S's self-reported performance or challenge G4S on its management of the centre, end quote. Following the broadcast of the Panorama programme and a number of reviews and reports into Brook House, the Home Office increased the size of both its on-site compliance management team and its on-site detainee engagement and casework team. Use of force. Each month in security meetings, G4S reviewed, among other things, the number, type and reason why use of force was used against detained persons. The number of use of force incidents would vary significantly from month to month, from 30 in April 2017 to 10 in the August of that year. The vast majority were unplanned incidents. During the relevant period, maintaining good order and discipline was overwhelmingly the principal reason provided by G4S staff as to why force was necessary. From the inquiry's analysis of the use of force documentation provided by G4S, this was provided as a justification for mostly unplanned use of force incidents. For example, in order to maintain good order and discipline, force was used to escort detained persons around the centre if they didn't comply with instructions. In one instance, this justification was employed in order to assist with the Home Office's removal process. Force was used on a detained person to obtain his thumbprint for the person's High Commission to produce an emergency travel document where he had been interviewed but had refused to comply with requests. Self-harm. Records provided to the inquiry collating instances of self-harm by detained persons show that during the relevant period, 60 instances of self-harm were reported. More than one of those instances might have related to a single person, as each instance is recorded as a new event. However, this amounts to a recorded average of 12 acts of self-harm per month at Brook House during the relevant time. A detained person required treatment off-site as a result of an act of self-harm 4 times during the relevant period. Assaults. G4S recorded various data on violent occurrences within Brook House. The records for the 5-month period which the inquiry is focusing on show that there were 30 assaults by detained persons on other detained persons, so 6 a month on average, 67 assaults by detained persons on members of staff, so almost 13.5 a month on average, 1 assault by a member of staff on a detained man, D2034, and 192 recorded threats of violence by detained persons, almost 38.5 a month. Incident reports and serious incident reports, IRs and SIRs or SIRs, were completed in a wide range of circumstances, including weapon seizures, drug taking and possession, fights, and escape attempts. During the relevant period, G4S found that while TS and FNOs comprised 35% of the detained population, they were involved in 51% of serious incidents reported and in 50% of all other reported incidents. Drugs. As to the prevalence of drugs at Brook House, the incident reports show that during the relevant period there were 190 recorded drug-related incidents, or an average of 38 a month. This might mean drugs or drug paraphernalia being found in the centre, actual or suspected drug use by a detained person, abuse of prescription medication, actual or suspected reports of visitors trying to bring drugs into the centre, as well as drug trafficking. Back to Rule 35. During the relevant period, 114 Rule 35 reports were received in respect of men detained at Brook House. In 31 cases, this led to the release of the individual. These were completed both by doctors working for G4S Health Services and by external clinicians, sometimes under the instruction of individuals, legal representatives, or charitable organisations. Rules 40 and 42. Rules 40 and 42 of the 2001 rules provide a power to those managing detention centres to impose further restrictions of freedom on those in detention where it is necessary for reasons of safety or security. Neither Rule 40 nor Rule 42 powers should be used as punishment, and both should only be used as a last resort when other measures have failed or are likely to fail. Rule 40, as I've said before, relates to removal from association, and it provides that a detained person can be taken away from other detained persons and accommodated in certified Rule 40 accommodation within the CSU. During the relevant period, there were 241 occasions on which the Rule 40 power was recorded as having been used. A number of these occasions will relate to the same individual. During that same period, Rule 40 was employed 48 times a month on average. Rule 42 provides that a refractory or violent person can be temporarily confined in special accommodation, also in the CSU. This power mustn't be used after the person has ceased being refractory or violent. And during the relevant period, the Rule 42 power is recorded as having been used twice. And finally, for this section of this opening statement, complaints, G4S and the IMB kept a record of the number of complaints made against G4S by detained persons. During the relevant time period, IMB and G4S combined reports show that 76 complaints were recorded, 12 complaints were wholly or partly substantiated during that period. A G4S spreadsheet on complaints suggests 40 complaints were received during the relevant period. They included complaints about unfair treatment, homophobic comments, alleged assault, harassment by other detained persons, missing property, failure to provide medication, etc. And we shall have to await phase 2 to see if the numbers can be reconciled. From our own analysis of the disclosure received by the inquiry, we found a further 4 complaints, wholly or partly substantiated after the relevant period, relating to events taking place during the relevant period or by the PSU. These included staff damaging the property of D642, failing to take action in response to a complaint by D668 that another detained person threw a bucket of water on him, assault and derogatory comments by staff towards D1527, a staff member assaulting D2953 on 3 occasions within 6 days, which I have already mentioned. And this excludes any complaints made directly to the PPO, the Prisons and Probation Ombudsman, and NHS England, about which we do not have clear evidence yet. Well, Chair, that completes the second section of the opening statements, and when I commence section 3, that will be to come into detail to look at the evidence, in particular Callum Tully and the Panorama programme. So can I suggest, it being 3 o'clock, perhaps a little earlier than we might otherwise have done, that we have a 15-minute break?
Okay, thank you. We'll return at 3:15. Thank you very much.
Chair, I'm now going to summarise some of the evidence to be heard during phase one of these hearings. And I begin, as I said a little earlier, with Callum Tully and the BBC's Panorama programme. Callum Tully is currently a BBC journalist. His connection with Brook House began when he responded to an advertisement for an assistant custody officer, an ACO, at Gatwick IRC. He applied online and was invited in for interview at Brook House, and he got the job. He became an employee of G4S at Brook House on the 6th of January of 2015, and he left in circumstances to which I shall come about 2.5 years later on the 7th of July 2017. He undertook his training for the ACO role and later applied to become a DCO, and following an assessment, he received further training over 6 weeks, which involved corporate training, in other words, G4S corporate training, searching detained persons and cells or rooms, first aid, fire safety, control and restraint, diversity and inclusion, and how to deal with self-harming and suicidal detained persons. One focus of the training was on the use of force and the detention centre rules, which make provision for the regulation and management of detention centres and provide for the welfare and privileges of detained persons, religious observance, correspondence, healthcare, and any complaints they wish to make, as well as the use of security measures such as powers of search and removal from association in certain circumstances. Callum Tully was assigned to the Activities Department. He recalls being told they may only use force when it was absolutely necessary, and when it was necessary, only the least amount of force necessary should be used. In other words, it shouldn't be disproportionate. He was familiarised with ACDT forms, assessment, care, detention and teamwork forms, used for monitoring detained persons at risk of self-harm or of suicide, and he was also familiarised with the use of force forms. There were also incident report forms which required completion when, for instance, a DCO witnessed a fight on the wing. He had a short period of shadowing more experienced officers and recalls receiving refresher training every 6 months or every year. There were 3 incidents in particular that led to Tully contacting the BBC. The first was when, as an ACO, he was in training with a DCO who was sitting in on the training. The DCO had been suspended for the use of excessive force on a detained person, but was on a phased return to duty. The DCO told him about an incident where he claimed a number of other staff members had been relieved of their duties because, during a night shift, they stood outside the cell of a detained person under constant supervision on E-wing, wearing George Michael masks, and danced while staring at the detained man. At the time, Tully wasn't sure whether to believe him, but he asked the DCO why the officers had done this, and his words to Callum Tully were to shit him up, which Tully took to mean to freak him out or to scare him. He heard the same story from another ACO on another occasion, but Tully never saw any evidence to validate the account. If it was true, it was, of course, a shocking account of abusive behaviour by the officers. The second incident was, however, one he witnessed himself while working as an ACO in what he calls the solitary confinement block, also known as the block. He'd been working in the gatehouse at the entrance to Brook House with another ACO, and was responsible for admitting a Taskor transport van, that's the escort company at the time, which was at Brook House for the removal of a detained person held on E-Wing. When the van arrived, his job was to buzz the van in, bring it into a sterile area and check inside and underneath the van using a mirror, and take note of the van's registration number and its time of arrival. He then released the second door. Because this detained man was refusing to leave and was being held in the solitary confinement block, the van had to drive around the perimeter road to get the detained person from the rear door of the block. And Tully walked alongside the van to escort it to the block because the Taskor staff didn't have keys, and he accompanied the Taskor staff into the block to collect the detained man. When he entered the solitary confinement block with the Taskor staff, the detained man was standing at his cell or his room door. And this was the first time Tully had been inside this part of Brook House. The detained man was completely naked, with around 5 staff members present, a mix of DCOs and DCMs, who were laughing and mocking him. He was shaking, he appeared scared, he appeared distressed. Eventually, the detained person was handcuffed before being ushered away by the Taskor staff and put into the back of the van that Callum Tully was escorting. Tully thinks the detained person was given some boxer shorts to wear. He wasn't able to see inside the Taskor van once the doors were shut, but could only hear him kicking, screaming, and begging not to be taken away. Of course, Callum Tully had no idea why the man was naked, and he didn't know whether there was a proper reason for it. However, what he did know was that it was wrong for staff to be laughing at him, and he was shocked by it. Tully says, to use his words, the man was humiliated and degraded by what was happening, which was, as he puts it, obviously unacceptable. He didn't consider reporting what he had witnessed. He'd only just started the job. He was 18 years of age. And although he knew the behaviour was wrong, there were senior staff around the detained man. He says he found the incident extremely distressing. And when he got home that evening, he made a note of what he had seen. And so he began to use a small black pocketbook to record incidents at Brook House, which he found distressing, as a way of processing what he had seen, and also because he felt he should record it. Despite this, he stayed on. First, he says, because he didn't know if this was behaviour which was indicative of systemic failings at Brook House, which allowed it to persist. And second, some of the staff members seemed good, compassionate people, and none of the ACOs he had worked with seemed capable of that kind of conduct. He also recalled that during his training, the need to treat detained persons humanely and with respect was repeatedly emphasized. The third incident he recalls witnessing before contacting the BBC occurred when he was working as a DCO. An American Jewish detained person was put in a head hold for refusing to go back to his cell for the 8:55 p.m. lockup. He was restrained by 3 officers at the request of a DCM. The detained man wasn't a threat to staff, says Tully, and was merely upset about the progress of his case, which is what he told staff at the time. Tully saw that he wasn't being threatening or abusive towards staff. He'd been sitting outside the library simply refusing to go to his room for less than 15 minutes before he was restrained. The restraint wasn't planned, but it was treated as a spontaneous restraint, even though the detained man hadn't been violent or self-harming. Tully felt, therefore, that the use of force was completely unnecessary. Staff should have spent much more time trying to find a way of convincing him to return to his room before engaging in restraint. His perception, Tully's perception, of the incident was because this was at the end of the shift, shortly before they were due to go home. Force was used because staff didn't want their end of shift to be delayed. And if his perception was right, then the rules regarding the use of force yielded to personal convenience. Tully's belief is that this behaviour reflected a broader culture among certain Brook House staff in which they showed apathy to vulnerable, disturbed or distressed detained persons and acted not in the interest of their safety or welfare, but with the sole intention of creating less work or inconvenience for themselves. He also found disturbing the general culture at Brook House. Some staff were apathetic, hostile, and sometimes aggressive towards detained persons, which on occasions would manifest into verbal abuse or excessive or unnecessary use of force. This was also reflected in the conduct of DCMs who were supposed to be in leadership roles. For example, one DCM described detained persons to him as cunts on several occasions. He found there to be an us and them mentality between Brook House staff and detained persons. He says Brook House was severely understaffed, which is a complaint repeated by other staff members, and staff turnover was high. In his view, there was a culture of abuse at Brook House among a significant minority of officers and managers. He adds the majority of DCOs weren't abusive. Many were hard-working, decent people trying to do their best in what he describes as a bleak, poorly staffed, highly charged and toxic environment. However, officers who were deemed too empathetic, helpful or kind to detained men were themselves often marginalized, criticized or mocked. There was, he says, a visible hostility to raising concerns. He recalled how the Speak Out posters, which notified staff of a confidential whistleblowing line, if ever they wanted to raise concerns, had the words snitches, grass, and don't be a rat scrawled across them. The IMB were also routinely described as snitches by members of staff. Perhaps unsurprisingly, Tully never seriously considered blowing the whistle internally within G4S. On the 12th of January 2016, Tully emailed BBC's Panorama, encouraged by watching a BBC Panorama documentary called Teenage Prison Abuse Exposed, in which G4S staff were secretly filmed abusing teenagers at Medway Secure Training Centre. And this was first broadcast on the 11th of January 2016, the day before Callum Tully emailed the BBC. A BBC journalist, Guy Grandjean, contacted him the next day, after which they remained in contact through to the spring of 2016, when the primary point of contact changed to Joe Plummin, who produced the Panorama programme that has led to this inquiry. the BBC decided to investigate Brook House, and Callum Tully was invited to become an undercover operative. He began his employment with the BBC on the 6th of March of 2017, and between then and the 23rd of April, he received training. He operated under principles that were set out for him in his undercover role, which included a risk assessment, legal guidelines, and other guiding principles. To carry out the role, he was equipped with a secret camera and microphone, which he wore during shifts, and would turn on to record events and conversations. At the end of a shift, he would meet with the Panorama production team and would then normally record a video diary entry to camera, of which I've made mention before. He would also hand over the camera with the day's footage to the production team. In the video diary, he would summarize the shift and any particularly notable events which had occurred. He recorded video diaries on 38 days in total during the filming period, which was from the 19th of April 2017 to the 7th of July 2017 inclusively. And the end of shift and the video diaries would be followed by a debrief with the production team. His first day of successful filming at Brook House was on the 24th of April. The last day of filming, and indeed his last day at Brook House, was the 6th of July. From the 24th of April to the 6th of July, Tully worked 37 shifts at Brook House and successfully undertook secret filming. On 34 of those shifts, there were equipment failures on certain days of filming. Selections from the filming over the 3.5-month period were broadcast in the Panorama programme, which, as I said right at the start, was aired on Monday, the 4th of September of 2017. The three instances of mistreatment that led Callum Tully to contact the BBC did not, of course, stand in isolation.
Very sorry to interrupt, Scott. We wanted, just before you start going through the incidents relating to this individual, just to make a quick message to the detainee who's watching and doesn't want to hear recounting the incidents that he's subject of. So if we could just have one moment, we will make sure that, because of the 3-minute delay, that needs to be taken.
Okay, understood, thank you.
If Miss Harrison had told me that earlier, I would have made that announcement myself.
Very sorry.
The Panorama programme showed other disturbing instances of mistreatment, such as the use of force, whether sanctioned but disproportionate, or unsanctioned use of force, albeit masquerading as the sanctioned use of force, or just plain deliberate acts of violence. The programme also showed verbal abuse and the mocking of detained men, some of whom had mental health problems, or were at risk of self-harm and suicide, or were the subject of a medical emergency. Chair, it's for you to decide whether any or all of this treatment was in breach of Article 3 of the European Convention and therefore amounted to inhuman or degrading treatment or punishment. Callum Tully lays emphasis on the fact that it was only a minority of staff members who engaged in this behaviour, but he felt strongly that the consistent and undisguised nature of the abuse demonstrated a systemic failing of the detention centre. Significantly, he says that in the majority of examples he gives, members of staff who were otherwise well-behaving officers were present during the mistreatment of detained men, which to him underlay the lack of confidence staff had in raising complaints about bad behaviour. He also makes the important point that although the abuse of detained persons was consistent throughout his time there, the staff members responsible for that abuse changed over time. Some abusive members of staff left Brook House, only for others to continue the abuse. In his view, this demonstrated that the abuse at Brook House couldn't be explained by a few bad apples operating unbeknown to others, but it was the cultural and systemic failings that gave rise to this behaviour, which allowed it to go unchallenged and dissuaded members of staff from raising concerns about it. As he puts it, detainees suffered as a consequence. For now, Chair, I'm only going to deal with a few events to which Callum Tully bore witness. They all featured in the Panorama programme. The first instance, and beyond doubt the worst, is the restraint of D1527 on the 25th of April, the day after Callum Tully's first successful day of filming. On that day, Tully had been working his regular shift of 8:15 in the morning to 9:15 in the evening. And during the latter part of the shift at around 7:30, he was on constant supervision, supervising a detained man on E-wing, when he heard noises coming from the far end of the wing and noticed that the door to D1527's room had been opened. He walked over to it, where D1527 was. And as he entered the room, he saw a DCO by the name of Clayton Fraser in the middle of the room, and a manager, DCM Steve Lawson, standing by the inner wall by the toilet area, looking at D1527, who was lying on the floor with his head by the toilet and his legs towards the inner part of the room. He was in a small space and movement was restricted due to the position of the toilet and the wall. D1527 was attempting to self-strangulate using something which looked like cloth. Tully left the room to get help, and he returned to the room to see that Lawton was using a knife to cut the ligature away from D1527's neck to stop him from strangling himself. D1527 was pulled from the area and placed on the bed to calm down. At this point, no restraint had been used. Tully and Lawton were then joined by others. D1527 stood up and went into a rage, making demands, visibly upset and angry. He then sat back down and put a phone battery into his mouth, attempting to swallow it. DCM Nathan Ring arrived, and he made several derogatory comments directed at D1527, which Tully says was normal behaviour for him. The situation then calmed. D1527's door was shut and locked, but within a few moments, noise came from D1527's room. Tully returned, and this time was joined by DCO Jan Pascali. In the room were Nathan Ring and a nurse, Nurse Jo Buss, and joining them were DCOs Charlie Francis, Clayton Fraser, and another nurse. Tully asked Jo Buss what D1527's problem was. She said, he's an arse, basically. When Tully asked Pasquale the same question, he replied, as Callum Tully recorded, acting like a 3-year-old. Nathan Ring commented, D1527 would start bouncing around like a Duracell bunny, a clear reference to the battery incident. D1527 was on his back in a similar position to before. Nathan Ring and Joe Buss entered the room, but they left, leaving Tully in the room to watch D1527 with Clayton Fraser. Tully heard D1527 choking, heaving, and gasping for breath with his hands around his throat, trying to choke himself. Tully asked him to stop and tried pulling his hands away, and then pulled him into the middle of the room, still telling him to stop. He called for help. Fraser was behind him, but wasn't doing anything. DCO Francis arrived, and Tully took hold of D1527's left arm, and Francis took control of the right arm to stop him from continuing to choke himself. Fraser took hold of his legs. At this stage, D1527 wasn't resisting, but he was in a state of distress. Pasquale then entered the room and knelt on the floor with D1527's head between his knees. He leant down towards his chest with his hands around the man's throat and his thumbs on the front of the throat and around the area of the Adam's apple. His fingers were down the side and back of his neck. D1527 became very agitated and then started to resist. Tully and Francis continued to hold his arms. Pasquale then exerted on D1527's airway what Callum Tully calls a phenomenal amount of pressure. He was now gasping for breath. Chillingly, Pasquale then said to D1527 in a quiet voice, "Don't fucking move, you fucking piece of shit," adding, "I'm going to put you to fucking sleep." Tully saw D1527's eyes bulging in his head, his face reddening, and he began to froth at the mouth. So concerned was Callum Tully that he said to Pasquale, "Jan, easy, easy." As Pasquale eased off the pressure, D1527 was struggling to communicate and was gasping for breath. Tully thought that Pasquale was going to kill him. Witnessing a suicidal man being choked by a member of staff was, says Tully, extremely upsetting. Let me quote him. "It was," he said, "an abuse of power which endangered the life of a detained man." The BBC footage shows these exchanges and Pasquale's actions just as described by Tully. The footage shows the incident continues with Francis ridiculing his behaviour, calling him a tool, an idiot, and a baby, and saying that they were getting bored with his behaviour. Staff members rolled D1527 onto his side and eventually left the room. Tully went to the toilet and cried. And later there was a conversation between Callum Tully and Nurse Buss about whether to record a restraint. There is a similar conversation between Pascali and Callum Tully. No use of force documentation was completed in relation to this incident. D1527 has requested that his face should not be redacted by blurring or pixelation in the footage the inquiry shows, albeit, as I indicated before, his name will retain the cipher and the subtitles, and the audio track will remain redacted. However, the unredacted footage, Chair, is not ready yet to be shown, so for now we shall only show the redacted footage. And I'm going to ask for the footage to be played, and to help the evidence handler, we begin with KENCOV, or KENCOV as we've come to call it, 1007. The clip number is V2017-0425, and we'll all get used to these references, or members of the public will. 0425 is the date in reverse, 2017-0425. 00020 is the first clip. And for the evidence handler, the clip times which we would like to play. And I note, Chair, we've got 10 minutes, but if we can bear perhaps just for the rest of this afternoon to play this out, because it's about 18 minutes in length. It begins at 08:47 and ends at 26:33. So if we can start the clip at 08:47, please.
Mr. Altman, maybe if I can just confirm with you, Ms. Harrison, that you were able to contact.
Yes, we were able to
Okay.
do that. We're having difficulties in the room, so my instructions
Okay.
just went outside.
Okay, thank you. Thanks. Thank
So
you.
here we are. Before we start playing, we can see the reference at the top left, KENCOV 1007. We will find a series of that kind of references. What KENCOV stands for, I have no idea. Maybe we'll find out, maybe we won't. But it's customarily joined by 4 digits. In this case, 1007. We'll work our way through to at least 1044 when we view or refer to different clips throughout this inquiry. Right at the bottom, we see the relevant clip, V2017, that's the year date, 0425, month and day date, 00020, and the evidence handler has kindly, at my request, started the counter at 08:47, and what I'm going to ask her to do is just to play it before she does. We'll see that there is an individual already in the footage. You can see his head has been blurred out, and that is what we're going to see. We will also see subtitles where ciphers, as I've understood it, have been retained, as well as in the audio track. Redactions have been made. And so we will view that, and as I say, it lasts very roughly about 18 minutes, I think. Thank you. So if we can just play that normal speed. This is one of those moments when you wonder if it's going to play at all, but I think it will. Can we turn up the audio, please, whoever's controlling the audio? Needs to be a lot louder. We can't hear anything. Just pause it for a moment, will you? I don't know if it's RTS controlling the audio from behind the scenes, but there's no audio that I can hear, or hardly any.
RTS have advised that the audio is down to the evidence handler.
Apparently it's your fault. So if you can crank that up, and if it's too loud, we'll let you know. And if not, we can sort it out, because we're close to rising time anyway, and it wouldn't be a disaster if we started tomorrow, I suspect.
We'll give it a go.
Can you play it again? We need to be louder than that as well. Any luck? I don't think so. I think, Chair, I'd rather hope that this might have been sorted out, but if not, rather than ask the evidence handler to try and sort this while we're all looking at her, let's see if we can perhaps, if you wouldn't mind, manage it and we'll play it tomorrow.
I think that makes sense, yes. Okay, thank you. We will reconvene
10 o'clock
tomorrow at 10. Thank you very much.